Today is March 12th, and welcome to the New Possibilities Hour, part of the Will Work for Food project. Founded in 2020 during the pandemic by Natalie Armstrong-Matan as a way to bring together a community of lawyers, mediators, and everyone who negotiates. These weekly seminars have been going on for 5 years now, thanks to your support and participation. As you know, each week our team here, Jeff Kitchaven, Jean Lawler, Natalie, and myself, David Schraga, brings you a new program with an amazing speaker to enrich your practice across multiple disciplines. As you know, there's no charge to attend these fantastic seminars. And instead, if you're so inclined and able, we invite you to make a donation directly to your local food bank to help us fight hunger. To date, we have raised nearly $1 million for food banks around the world, thanks to our generous audiences, as well as the participation of our fantastic speakers. We are really privileged to have an amazing speaker with us today, someone I'm glad to say I have known for a long time, and we couldn't be more delighted to host Yakub Hazzard today. The title of today's program is Competing Perspectives and Common Interests, Strategic Mediation on behalf of artists, studios, and other players in the media and entertainment ecosystem. And there really is no one better to speak on this subject with us today. Just in terms of a brief biography, Yakub Hazzard is the chair of Mitchell Silberberg Knupp. He specializes in litigating high-profile matters involving intellectual property, right of publicity, privacy, breach of contract, profit participation, and other media and entertainment-related contracts, really across a wide range of industries. He also has significant expertise handling employment litigation matters for clients as well. Yakub has a great professional story. He began his career at MSK in the 90s, developing his entertainment litigation practice as the firm was representing Recording Industry Association of America and the Napster dispute, and many other prominent cases. Over his career, he's represented an array of entertainment industry clients, including Berry Gordy, the Ray Charles Foundation, Weezer, NBC Universal, Universal Music Group, and many others in litigation that spans copyright, trademark, right of publicity, and contracts. His clients have also included foreign distributors and leading video game companies as well. At NBC, his most recent role prior to returning to MSK was handling all the profit participation audits and litigation for the company's television, film, and consumer products businesses. He also oversaw copyright, trademark, and general litigation matters as well. But as I've explained, Yakub has also been on the talent side, representing artists for many years as well. And so this combination of being on the talent and studio side is really a rare perspective on how the industry works. So in this dynamic seminar today, Yakub is going to talk with us about how advocacy and settlement strategy may differ depending on the client's market position and leverage. And with his diverse background representing stakeholders on both sides of this industry, he really is the perfect person to talk to us about how these cases come together and how they get settled as well. So Yakub, thank you so much for being here with us today.
Well, thank you, David. Thank you for that glorious introduction. I didn't know who you were talking about there for a minute. One fun fact you left out that I just would add is that before even going to law school in 1986, I was a paralegal at Mitchell Silberberg Knupp for a year in between undergrad and law school. So I've held almost every position at the firm except, I think, receptionist. So
Yeah, fantastic story. You've done the full spectrum of jobs over there, it sounds like.
exactly. But it's a pleasure to be here, and thank you for the invitation.
It's our pleasure to have you. It's really a testament also to sort of how the community of entertainment industry litigators and lawyers work within LA. Really can be a somewhat small knit community with some firms like Mitchell who are really at the core of the business for a long time for a lot of clients.
Yes, absolutely.
Well, yeah, Will mentioned this, once upon a time we worked together a couple different places along the way, and I've obviously valued your mentorship and expertise over those years. So, Yakub, let's start with I think the thing that really is very valuable about your perspective here today, which is oftentimes in Hollywood, people can be studio side or they can be talent side, and you, as I mentioned, have this rare perspective, having worked on both sides of the V, as litigators might like to say. That vantage point is rare, and I'm wondering, when you walk into a mediation, so what changes for you depending upon the side that you're representing? Like, you've been in both rooms, so
Right. I've also been the client as the in-house person from NBC Universal, so that's a third perspective I can bring to the table a little bit. But yeah, as outside counsel, when I'm walking into a mediation, what really changes depending on the side I'm on is the amount of hand holding involved, right? And that's particularly true when, I'm representing someone on the talent side because typically, talent is not hopefully that familiar with litigation generally and usually pretty nascent when it comes to their knowledge of mediations in particular. And so it takes a lot of time to really explain the process. I mean, this is true throughout the entire life of the litigation itself, but when it comes to mediation, it's especially important because, as you and I know, having been around and done mediations for years, they have a different kind of pace. They can be a little slow. They can come across sometimes as tedious, and these are things that you really want to prepare the talent client for. A lot of talent are used to kind of getting their own way, moving at a real fast pace, and you need to explain to them, look, this is going to be most likely a slow process. Um, you know, don't get impatient, bear with it. The mediator is doing it the way the mediator is doing it for a reason. They're experienced in doing this. And, there's a bit of a dance that you have to do in these mediations, particularly at the beginning before you kind of get down to brass tacks. I also have to explain kind of what the role of the mediator is, right, in greater detail with a talent client. They need to understand the mediator is not there to decide anything. They're not the fact finder. They're not the decision maker. They can't make you do anything. They're there to try to broker a resolution that both sides can either live with or both sides hate. I always say in either event, you probably reach the right result, right? Both sides are happy or both sides are equally unhappy. That means a true compromise was probably really achieved in either of those instances. So you just need to really manage those expectations with the talent. And then that really starts well before, the mediation process begins. It's as you're talking about, maybe we should go to a mediation, you begin to explain exactly what that means and why that might be valuable. And it's a series of conversations that you'll have in getting the client prepared to understand what the mediation process is going to be like. On the other hand, the exact opposite is typically true when you're representing a studio or a company because you're most likely dealing with an in-house lawyer who, attends mediations all the time, understands the litigation process, and there's not nearly the same level of that kind of preparation required because, they already kind of know the ropes.
There's a lot of really interesting stuff in there. I mean, one of the things that comes through is that when you're working with talent, these are really individuals who don't really have necessarily the same experience with the system. And at the same time, these can often be very emotionally charged disputes, right? From people who are highly creative. There's a lot at stake for them. I imagine in addition to the hand holding, a lot of it is sort of being able to facilitate an opportunity for them to get their story out, right?
Absolutely. I mean, you're right because that's the other thing that's very different when you're representing talent in the company is that for the talent, the dispute is usually a lot more personal in nature. For example, if you're representing someone who's being accused of copyright infringement by someone else, I mean, that they view as almost a personal direct attack on them and their reputation. And so there'll be different emotions that will be involved in that kind of a situation. So in addition to the pre-mediation handholding, you may have to play the role of a little bit of a psychologist. And particularly the mediator may have to play that role. It's not that different from how mediations kind of began in the employment context, right? That's where mediation kind of first propped up and really grew is mediating employment disputes, the wrongful termination, harassment, and the like. And in those cases, right, for the employee or the former employee who's bringing the claim, it's very personal for them. They lost their job. Maybe they felt that or if they hadn't lost their job, maybe they felt that they had been, mistreated somehow by the company or some people at the company. And there's kind of a cathartic process that the mediation gives them to kind of more or less vent, get things off of their chest, tell their side of the story, feel as though they're being heard by a third party who, presumably will show some empathy and understanding as to what that person is going through, because that is kind of a part of the process. Because until that party kind of gets that out of their system, it's hard for them to turn to trying to settle the actual underlying lawsuit or dispute. And so it's very similar when you have artists. I mean, I had a case where a artist client of mine was accused of failing to account properly because he also had a company that exploited the content, and he was really offended by it. He was
Yeah.
really offended by it, but and talked about how offended he was about it for the first quarter of the mediation, right? And but then once he got that kind of off of his chest, and we were able to kind of not so much examine the merits, but just kind of examine the cost benefit analysis of settlement versus proceeding with the litigation, which then backs into what makes the most economic sense given the risks involved. And then we were able to have a rational, not that the first conversation was irrational, but a rational discussion around what would make sense as far as getting the case resolved.
Yeah, I mean, you could go through that process and get to the end of the day, but you still have some work to do to help them understand that, the next question becomes what happens tomorrow if we don't settle the case, right? And we have
Exactly.
to this process.
Yep. The parade of horribles that could happen if the litigation continues. Exactly.
Well, and I imagine from having video side, you probably have a perspective on what's happening in that room as well. And I mean, one of the things that I wonder is, because we have this dichotomy in the industry where it's often studio lawyers and people who have represented really just one side of the business for their entire career, there must have been cases where you're sitting in the room for the studio, and you have sort of a unique perspective on what the plaintiff or what the artist really needs to go through, and that the studio needs to understand as a part of the resolution process.
Yeah, that's absolutely 100% the case. And one of the advantages that I have, having been on both sides of these types of disputes, so I had a matter for a studio client. It was a profit participation case involving a very old television property that had a very old, like literally 2 pages, like net profit type definition that left a lot to be filled in, right? So it was not the most complete, comprehensive document you've ever seen. But I had represented profit participants for a number of years at that point at my prior firm, and not only was I familiar with kind of the approach from that side in these cases, I also kind of understood the reality and emotions of profit participants in these kind of cases, and notwithstanding how much lawyers representing talent will pound on the table about how their client wants to have its day in court and bring down a Hollywood accounting system and do great things for all artists to come in the future. The reality is they'd rather get their money than being a lawsuit. And that's especially true when, in the case that I'm talking about, we were dealing with older properties, and that meant an older profit participant. And so, does he want to really spend another year and a half litigating a case hoping he's going to get a big home run, or does he want to make a deal now and have his check within 30 days? And so I knew that I was familiar with that dynamic, having been in the other room representing the profit participants, and I knew that was probably the case in the matter that we were mediating. And so that allowed me, and I had to convince the client that I was probably right about this, but that convinced me that we had more leverage on a practical level than we than the client thought going into the mediation. And I kept telling the client, look, I know the other side is pounding on the table how they're going to get punitive damages and this, that, and the other if they go to trial. I said, but if we make a reasonable offer that we think reflects the true value of the case and kind of stick to our guns, quite frankly, because it was going to be a sizable amount of money to begin with anyway. I said, I bet you at the end of the day, and it may literally be at the end of the day, and in that case it was pretty late at night, that the profit participant plaintiff is going to ultimately not capitulate, but will settle for something much closer to where we wanted to settle than where they came in at the beginning of the mediation. Lo and behold, that's exactly what happened. And that's because lawyers like to talk about the legal strengths and weaknesses of a case. But the client, particularly a plaintiff in a profit participation case, they just want money. They don't need to, they're not trying to set a precedent for the rest of the world. They're trying to get their money, particularly when they're in the golden years of their lives, so that they can enjoy that money with the rest of the time that they have on this earth. And that played out perfectly for us in that case.
Well, and it goes back to what you were saying about how these can be such emotionally charged matters, and they can be complicated because people sort of go for years receiving statements without seeing money, and these litigations can become very important to them. But But there's something important, I think, in what you said as well, in terms of not just understanding the studio's leverage because of the perspective you had, but you also said that we had to make a reasonable offer, right? And I
Right.
think that that perspective and having the insight of representing talent must also help you sort of approach a mediation in a way where need to give them a way out, right? That they can at least be comfortable with. You can have all the leverage, but if you back them into a corner or it's not going to work, even at a late stage in life, I imagine you might still get some resistance.
Yeah. No, that's an excellent point. It really
Yeah.
is. You
And
know,
I,
the other time that this being on both sides, having the experience of being on both sides of the table or in both rooms helped was I had a case for a video game company that was being sued for right of publicity violations, and the claims were being brought by a company who had acquired the publicity rights of some famous poker players, right, or famous people that would appear in this video game, and I knew because I had represented plaintiffs in right of publicity cases, kind of what the claim was worth and what the settlement value was really worth. And we had gotten to a point, and my client was really anxious to get the case resolved. They didn't want to pay crazy money, but they really wanted to get the case resolved for their own reputational reasons at the time. And so we had gotten to a point where I knew, my client knew, the mediator knew, and I think you mentioned his name earlier. Was the mediator in that case was Jeff Kitchaven. He knew that the amount of that we were offering on the table was more than reasonable. It was probably better than they would most likely do in the litigation, and that they really should take the deal. But it became clear to everybody that the the client on the other side knew that his lawyer didn't, and the lawyer was literally trying to block settlement. And we were trying everything within our power to kind of move the lawyer off to the side because it became apparent to me because the person was not an experienced lawyer in this area, right? Did not do entertainment type cases, just some kind of random litigator off of that did regular commercial litigation. So we tried everything. We tried, well, why don't we just have the clients meet with the mediator without the lawyers? Lawyer wouldn't agree to that. Why don't we just have the clients meet with one another with no one else present, just talk, person to person to see if they can kind of come to a resolution. Lawyer didn't want to do that, block that. And so we're kind of sitting there wringing our hands, and the mediator comes in, it was Jeff, and he says, their client just went to the men's room. And I turned to my client and said, go get him. He went into the bathroom and they talked while they were standing at the urinals and they settled the case and they came back. And my opposing counsel was furious. But I'm like, hey, what do you want me to do?
hey, talk about a sidebar, I mean,
Right?
is in favor of these mediations coming back to being in person as opposed to on.
Yeah, that's not something you can pull off in a Zoom mediation, unfortunately.
But I think also speaks to an important aspect of the industry, which is um, the importance of custom and practice and knowing how to evaluate these claims and how that plays into settling, right? And I think it sounds like what you're saying is that the lawyer on the other side, depending upon their expertise, and if you have a partner who really sort of knows the landscape in the same way, can make a big difference in terms of how you approach things.
Yeah, I find it much easier to litigate against and mediate with, lawyers that are more experienced in the industry than lawyers who are not, because they just don't come with the same baseline of information. They're not as familiar with, as you said, the custom and practice in the industry, kind of what's standard, what's not standard, what certain rights are worth, what certain things are worth, and so that makes a big difference. There's nothing, in my personal opinion, more frustrating than, for example, litigating a profit participation case against a lawyer on the other side that has no idea what a profit participation is and has never litigated one before and thinks that, it says net profits. You guys, the movie made 44 million in the opening day box office. There's got to be a profit for my client. Well, that's not how it works, as we all know, but to a layman or an inexperienced lawyer or one who's not experienced in the industry, they don't necessarily get that, and that makes the work a little bit harder on our end. In
Yeah.
those instances.
Yeah, and I imagine sort of pivoting to when it comes to working with mediators, do you experience a similar dynamic in your cases where, it's important to have somebody who really knows the subject matter? I mean, some areas are music are very sort of subject matter intensive. Although I imagine a lot of what you do is contract matters. How do you think about how to select the right mediator for a case and extending that to if you're representing the artist? or the studio? Does that change your calculus?
Yeah, well, obviously, I'd like to get a mediator that I've had some experience with, if possible. That usually is my first choice, is using someone I've had prior success with. I like to get someone who's knowledgeable about the subject matter. If it's a copyright case, a lot of times you want someone who's got copyright experience. A lot of times, a retired federal judge is a good choice for something like that, right? Because they presumably have presided over a number of copyright cases in their judicial careers. Um, the other thing I like to do, if where appropriate, is I'm a big proponent of, where possible, selecting a mediator that the other side proposed. Because I think that, if it's the person's mediator that they selected, they're more likely to listen to that person. They're more likely to be persuaded by that person. They're more likely to have trust with that mediator. And so I think that, especially if it's talent on the other side and their lawyer is, making a proposal, it's a good thing for them to say, the lawyer to say to the talent, well, they selected one of the people that we proposed. So I think that's a good sign going into the mediation. I think that often gives mediation a greater chance of being successful. And it's something where I try to do that.
Well, and it sounds like, especially when it comes to if the talent has proposed the mediator, then it probably sounds like that, that the sort of spectrum of skills that you explained needing when you're in the room with the talent is something that probably their lawyer is more likely to hope that they're going to have available to make the process more effective.
Exactly. Exactly.
So I wanted to sort of go back to something you had talked about, and you mentioned the term reputation. And reputational issues are so important in so many industries, but really in the entertainment industry, because of the role of public eye, the high profile nature of these matters, it can be critically important. For artists, I mean, it can be career defining, and for studios, it's really sort of an institutional and shareholder facing credibility issue for them, right? So I guess, how do the reputational considerations differ across the constituencies that you're representing, whether it's on the talent side or the studio side?
Yeah. So on the talent side, it's more of a personal reputational issue, right? Because they're an individual, particularly if they're a defendant, they're being accused of some alleged wrongdoing, and they're typically highly offended by that and become very defensive, and sometimes very strident in their denial that they could have possibly done anything wrong. And so there's a little bit that you have to overcome on that side with them when it comes to those reputational concerns. When you're on the studio side or the company side, it's not so much reputation as it is really precedent for a lot of these companies, right? Where they don't want to set a precedent of conceding and paying off certain types of claims or admitting liability, or they're afraid that this could open the floodgates. Word gets out that they said, oh, this case is going to be 400 plaintiffs lined up trying to get the next check out of them. And so that's something you've got to manage when you're working with the studio side when it comes to kind of reputational damage. The companies aren't so worried about their reputation as a company, I don't find, as it is the kind of precedential value that what they might do could set, and how that could impact claims in the future, or the way they resolve and handle claims in the future. That's been kind of my experience when it comes to that issue.
And I imagine, look, you hear a lot of these studios, they talk about wanting to be a talent-friendly environment, right? And so from a reputational perspective, many of them are very loath to actually sue the talent, on the one hand. But I imagine when you were in-house, you probably dealt with a lot of pre-litigation resolution of claims that involve disputes with talent, sort of because it doesn't really help the company to be out there suing talent. I mean, is that something that you were across with any frequency?
Yeah, well, I'm a big fan of like pre-filing mediation. I think that it's usually a good idea to try to see if you can resolve the litigation before you get into an actual lawsuit. One of the senior partners at MSK taught me. We used to always say, and I remember this from being a young lawyer, he would tell people, you're not in a lawsuit until you're in a lawsuit, and once you're in a lawsuit, you may not be able to get out when you want. Right. And so that's what I tell clients, when the idea, well, let's maybe try to mediate or discuss settlement before we actually get involved in the lawsuit or the arbitration. I recommend that most of the time, because for the reasons I just said. You can really, first, you can save the client a lot of time and money if you're able to resolve the case without ever having to file it. You can achieve oftentimes a better outcome by doing that because the other side may be more willing to be a little bit more generous because they haven't spent a lot of money defending a lawsuit or an arbitration up to that point. So, it's almost like when you're dealing with an insurance company, right? And they've got a limit and you have not run through a bunch of that limit on defense costs. And so there's more money available from the policy to throw at a settlement than there would be if you had litigated the case for 2 years first and now only 10% of the limits remaining. They don't have as much flexibility at that point in time. And so I'm a big fan of pre-filing mediation where appropriate. And in most cases, I think it is appropriate. I know there are other lawyers who do it differently, particularly ones that represent talent where they like to file and get the big media splash first and then sit down and try to get the case resolved. I think we know who some of those lawyers are. We won't name them. But that's not my personal approach again, because you're not in a lawsuit until you're in a lawsuit. And my goal is to try to solve problems and get positive results for my clients, not necessarily file and win a lawsuit. That because a win may not necessarily be a real win at the end of the day, depending on the final outcome.
Well, yeah, once they get filed, they get dragged into it, like you mentioned. And a lot of times, with these disputes, pre-litigation context, there's a conversation about how embarrassing this might be, right? And how to deal with the discovery. But as sort of once you file the suit, you kind of lose that leverage, right? Because it's out there. So I imagine there's a delicate dance that you're doing in those situations as well on both sides.
Yeah, absolutely. Absolutely. Because the publicity, not all publicity is good publicity, notwithstanding what some people think.
Well, I mean, I guess that goes to the question of the filing strategy and the settlement strategy for controlling the narrative, right? I mean, you must have experience where folks are filing these lawsuits, not just to make a splash, but because it's important then to get their side of the story out first. How does that affect how you think about positioning a case, or maybe sort of the value in that for prompting a dialogue?
Yeah, I find that those make the cases sometimes harder to get back on track for a settlement, right? Because the obvious purpose of the other side going public with some things is to tell their side of the story, which usually means it's making the other side not look so good. And so a lot of times I find that can be counterproductive in certain situations, but not always. But again, that's kind of not my style. That's not, and I don't practice in that kind of an area where a lot of that happens. A lot of my disputes are that I have like more profit participation, intellectual property related, and as opposed to these kind of talent versus studio 7-year rule kind of. I'm trying to get out of the contract or we saw a lot of these at the beginning of COVID where people were filing these lawsuits against the studios who were, instead of debuting the movies in movie theaters, right, where the participant has a box office bonus, they were going straight to streaming, and there were accusations and lawsuits being filed, very high profile, only to be settled right within a week of the filing of them. Of course, I'm not sure what box office receipts they were going to get in those cases. Where we were in a lockdown at the time, and no one was going to the movies then, and no one's really going to the movies as much now. But that was a different kind of a situation where someone did want to get their side of the story out first and use that as leverage to settle the case. And a lot of that depends on the leverage that each side has. I mean, I can tell you that when you start talking about leverage, it really boils down to the talent side, because the studio is the studio, but the bigger the talent, the more leverage that talent probably has. And, I've seen that manifest itself not only when I was representing studios or companies when I was outside counsel, but when I was in-house. I mean, there would be a number of times, and a lot of this would be pre-litigation where a dispute might come up, but it's, a dispute with really important talent for the company. And there are a lot of times where, notwithstanding what the litigators want to do, or even sometimes what the business want to do, the creative executives will get involved and say, no, we are resolving this because we need so-and-so, back on set in 2 weeks or whatever the case may be. And so, but the flip side is also true, right? If it's not big name talent, then they don't have as much leverage. And the studios know that because there's only a handful of buyers for the talent services, right? And fewer and fewer buyers as every day passes with all the consolidation, and that they've got the leverage, and they know that the artists would be crazy to really push it and go all the way because that could affect their ability to get work in the future.
Yeah, it's a fascinating dynamic. Just and I think it is driven by the fact that it's a small community, right? And
Right.
it's
That's back to your point earlier. Yeah.
yeah, and it goes back to what you were saying, sort of about these lawsuits that get filed, maybe as a publicity maneuver. But I think part of what's underlying your observations about that is that they reflect to some degree a breakdown in trust, right? And I'm sure from being within the studio and working with the same players over and over again, and it might just even be lawyers who represent different parties. I imagine that to facilitate these settlements, and these conversations, maintenance of trust is critical for what you're doing.
Very, very important.
So, um, there's another really interesting aspect to the studio and talent ecosystem that I'm sure you deal with quite a bit, and I wanted to pivot to, which is talking about the roles of agents, managers, and really sort of layered representation when working with artists. And they occupy a very interesting niche within the business as a go-between between the studios and the talent. And often they're an important part of the team when you're the lawyer, right? Representing the artist especially. So how does that representation dynamic shape your negotiation dynamics and sort of what both sides of the case are managing in a mediation or in a dispute?
Yeah. Well, so on the talent side, right, the talent has his own uh, team of advisors, right? You'll have an agent, you'll have often a manager, sometimes a transactional lawyer, and depending on the nature of what's going on, maybe a publicist is involved. And what I like to do, well, first of all, usually the agents, once you get into litigation, they throw their hands up. They're like, "I'm out of here. We're not, call me when it's resolved," because they don't want to get involved and be considered the face of the dispute on behalf of the talent because they've got to deal with the studios on behalf of all their other clients, and so they kind of extract themselves from the situation right away. Then that usually leads the managers and the transactional lawyers. And lots of times they will be the ones that attend the mediation, right, along with the talent that you're representing. My personal preference, when I can pull it off, is just to have the talent there alone, have the business manager or the manager available by phone, and maybe have the transactional lawyer also available by phone. But that doesn't always happen. But one time I was able to do that. I represented talent, and they were being sued, and it turned out that I learned at the mediation that the plaintiff that was suing my client was like his second cousin, right? Their mothers were cousins, and the plaintiff, the second cousin who was suing my client, had been pretty instrumental in my client's early professional success. He had produced a bunch of the recordings that had made my client famous, but then unfortunately for the cousin, as I'll call him, the cousin plaintiff, he kind of fell on hard personal times and had problems with the law, and his life just went in a very different direction. Meanwhile, my guy kind of ascended to the throne and became a multi-millionaire, ended up, crossing over into film and TV and became a real major Hollywood celebrity. And what kind of came out during the mediation was that my client had a certain level of guilt, personal guilt, that he had become so successful, and his second cousin, who kind of started off with him, didn't become so successful and was really struggling at this point. And at the same time, he really wanted to settle the case, and he frankly agreed to settle the case for probably more than it was worth. He did get some things in exchange for that. That were really more personal to him than business related. And I remember when we settled the case, and then we decided, all right, let's call the manager and let him know what we did. The manager couldn't believe it. Like, I can't believe he would pay that much money. And the manager started to get mad at me. And I said, look, first of all, he's the client. It's his money. He gets to make the decision. There were some things going on in this relationship and in this dynamic that you were not aware of. In fact, I wasn't aware of until the mediation began. and we were able to get it resolved that way. But unfortunately, I'm not always able to convince the managers and the transactional lawyers not to attend the mediation. And so when they do attend, you just have to understand that the mediator has to understand, all right, they're in the room, they've got their own perspectives and maybe agendas a little bit that are a little different than what the client agenda might be. And that, you just have different audiences that you've got to speak to and listen to throughout the day and throughout the process. On the other side of the table, right, when you're representing the studio, usually you'll have an in-house lawyer as a client representative, and you may have someone from the business as well present because they oftentimes are the ones who have to authorize the writing of the check if they're the defendant. And usually that dynamic is the parties are, or those constituents are a little bit more aligned than what I sometimes have to face on the talent side, where you got the dynamic of the talent, the manager, and the transactional lawyer. But typically, they're like I said, they're pretty much aligned, and there's not nearly as much kind of intra room negotiation that you have to do there. And it also helps because typically they're very experienced um, as litigants and participants in a mediation. Then the talent of this may be the first and only lawsuit they've ever been in, the first and only mediation they've ever attended. Manager maybe has some experience. The transactional lawyer knows a lot about it, but just enough to know that they don't want to be a litigator. And so, that's kind of how it plays out differently when you've got the different constituents on each side of the table in each room.
It's interesting because sort of telling that story about what you discovered in the mediation with that client really reflects something that mediators talk about a lot, which is the importance of taking the time in the mediation to really understand sort of the interests behind the positions and really the underlying dynamic that is
Yeah,
on in a dispute, right? And to be able to separate people from that. Although in this case, it actually sounds like it's really important to bring it together, right? And to sometimes be responsive to that.
yeah.
I imagined I think it probably creates some dicey situations for mediators, right? When you're in a room with the group of talent reps and it feels like there's this divergence between maybe what's good for the client, what the transactional lawyer is feeling, where the litigator is. I mean, are there any techniques that mediators can use? You mentioned being conscious of the audience. Do you find it helpful to have sidebars? Are there things that you see effective mediators doing to try and sort of extricate, from that situation?
Yeah, well, the first important thing is, this goes without saying, is the media has to be, a real active listener to each person's perspective to really kind of understand what the interests, what the important interests are for that particular person. And then I do find that oftentimes when you have that kind of dynamic, maybe just meeting with the lawyer without the without the client, and the other reps can be helpful because the lawyer may already have a sense of what those interests are and understand that dynamic that he or she can share with the mediator, or the lawyer's learning it for the first time themselves, and they can kind of talk with the mediator about how to best manage that from the lawyer side and from the mediator side. But that can often be a very helpful a tool. And the media can say, "Look, I just want to talk about a couple legal issues just with the counsel," and then kind of have those conversations and kind of strategize on the best way to kind of break through that dynamic so that you can have a productive dialogue with the other side. Because you can't settle the case if you spend all the time in one room, trying to mediate among the parties on that same side.
Put them all in different rooms, see what happens.
But there is
But
an aspect of kind of a mediation within a mediation sometimes that the mediator may have to do when that dynamic displays itself.
yeah, I'm sure you deal with insurance coverage issues and things like that that probably create the dynamics within rooms like that. Um, you were talking about sort of how to tip off the mediator to these dynamics. It makes me wonder and think about sort of pre-mediation conferences. And do you find that to be an effective thing? Do you like when mediators do that? Are there certain issues you want to be able to explore? How do you think about preparing for
I
pre.
think that pre-mediation conferences are very helpful. They can save a lot of time at the mediation, right? And I think it better prepares the mediator for when they show up for the mediation to do meet with the client. I like it when the mediators have just the pre-mediation counsel conferences with the lawyers, and just kind of have an open conversation. All right, what do you guys think will be the best way to approach the mediation that will be have the highest probability of success? And we can kind of talk through those things. Are there any unique things that the case involves that the mediator should know that could impact the settlement of the case or the emotions behind the case and things like that? I also find it helpful when not only the mediators have the pre-conference mediations with both sides, are also caucus independently with each side for a little while before the mediation begins. Again, if nothing else, it will save some time, and I do think it allows the mediator to be much better prepared for when the day of the mediation comes.
So I want to go back to something you talked about when it comes to sort of what's happening in the studios room during these mediations. And you talked about having the in-house counsel there, as well as, usually a business executive who has some connection to the dispute, maybe, right? Or whatever business line it arises within. And I'm just wondering from your perspective, having been in-house, what are the effective things that in-house lawyers are doing to work with their clients internally to position a case for settlement? But I also imagine that there must also be an element of emotion when dealing with a studio executive. It goes back to what we talked about, which is a small community. There's a lot of repeat players, and they have an interest in the long-term approach to these relationships too. I mean, there must be some challenges you deal with as a studio lawyer when you're dealing with high-powered executives who have sort of been banging around with lots of the same people for a long time.
Yeah, it's there. That is a dynamic, that's for sure. Often what happens in my experience is that the company sends an in-house litigator, and then usually someone from the business. A lot of times it's the lawyer for that business, right? Who's like responsible for that, and not the actual executive. And
You're
so you
saying,
do have kind of a person missing from but the lawyer has got the authority, right, to settle because they've been given it from the executive. Um, but you're right. There are some situations where the executive is taking the claim personally for whatever reason. Doesn't like the fact that the studio is being accused by whatever the talent's accusing of doing, and can be a little bit more difficult. But I do find that even if the executive is not in the room, if you can convince the executive's direct representative, in this case the lawyer from that business unit, then that person can usually have pretty decent success in working with the executive and getting them to come around if that's what needs to be done to make a settlement that makes sense happen. But that goes back to years of trust between the person who's in the room with you and the executive that they report to. If you don't have that kind of level of relationship, it can be much more of a challenge. And so that's why a lot of times, mediators and even the other side of the mediation will want to insist that a particular person or a particular executive attend the mediation, or at least be available by phone during the mediation, in case there's a need for a mediator to talk directly to that person who's the true stakeholder on something like that, but is not necessarily in the room. And sometimes it can be logistically not possible for them to be in the room for whatever reason. And a lot of people will accept, okay, well, they sent the in-house counsel who's got the settlement authority, even though they're not really the person at the apex of the organization, just because as a practical matter, it's either that or you'll never get the thing scheduled. Um, so that could be a dynamic, but that there may be a need where the media has to get on the phone and talk directly to that executive, or talk to that executive if they're in the room directly, to kind of break through any kind of logjam that may exist that is blocking the possibility of a settlement.
Yeah. So I mean, when you do, it's an interesting dynamic, and I mean, it must just really be case by case, right? And
It
who's
is.
in every single one you deal with, and it kind of goes back to what you were talking about, which was sort of relationship as well as the in-house lawyer really knowing the business, right? And being able to talk with the client about what's best for the business. But within the studio system, there's so many stakeholders. If a mediator hears something like, I need to check internally, or I need to go back and talk to somebody. How do you read those tea leaves in terms of what's really happening? Is it
Usually that means that the case is not close to selling, but you're making progress, and the mediator is giving that side, that studio side, something to really think about and talk about. Maybe they're in a range monetarily where, okay, so maybe it's a little more than they wanted to pay, but we're getting close. Let me have an internal conversation and figure out how we want to respond to that. Or an issue has come up that the company wasn't really prepared to give on, but then after hearing something that the media had to say, maybe we should reconsider that. Let's get on the phone and based upon what the media has just said, talk that through a little bit, because that might open up an avenue to get the matter resolved. So if I were a mediator and I hear the other side say, or one of the sides say, well, we need to get on the phone and talk about something, I would consider that as a good sign. That means that there's something that they at least think is worth talking about, as opposed to, what, that's a non-starter, we're out of here, kind of a response. And so I would think, if I were a mediator and heard those words, I'd think, oh, good. All right, well, maybe we're getting somewhere. It's kind of what would be my reaction.
progress, right?
Yeah, we're making some progress.
Let me pivot a little bit and ask about intellectual property within studios. I know that's been a big aspect of your practice, and one of the things that I think distinguishes these types of cases for studios from so many others, and we often sort of say, for corporate clients, not all cases are created equal, right? For a studio, where it's monetary dispute versus something that involves IP that might go more to the core of the business or some things that are happening. How does, when premium intellectual property is at stake for the studio, how does that change the settlement calculus, or how does it change how you approach a settlement if you're representing the talent and you have a dispute over ownership of IP, or how it's going to be exploited?
Yeah, well, I would say it depends on the nature of the dispute. So if it's an infringement case, then the IP owner is going to want value appropriate for the IP that's been infringed, right? So if it's extremely valuable IP that's been infringed, then the IP owner is going to want a high settlement, right? Because that's worth a lot more money than it goes to the core business. By contrast, if the IP is not as valuable, then I think it's kind of probably a lot easier to settle those types of disputes. And of course, from the claimant's point of view, their IP is always extremely valuable, whether that's in fact true or not. But more importantly, in their mind, the infringing work, the value of the infringing work is driven entirely by the piece of the work that the plaintiff claims belongs to them, right? It's the hook of the song. It's the key element of the movie. It's the most important part of the whole thing. And so then they're driving for a higher settlement amount. And then there are different types of cases, right, where there's a dispute as to ownership or who owns certain rights with respect to some intellectual property. And a lot of times, those types of mediations really involve a lot more than just a check right now and maybe a continuing royalty, but like, who's going to own valuable rights in the future, and how will the proceeds from those valuable rights, whether exploited by one side or the other or both together, how are those going to be shared and split? It becomes more like a true business dispute, right? And that's where I think a mediator's got to kind of think about the long-term ramifications of what the settlement structure is that they're proposing, how that could impact each side in the dispute, and really kind of put on their business person hat as opposed to their risk evaluation kind of hat, and trying to broker a deal that might make sense for both sides.
It sounds like there's really an opportunity for a lot of creativity there, and I imagine, for sort of having been on both sides, it probably gives you some great insight into maybe where there is room for more flexibility on the studio side than they're saying, or different structures that maybe can be available.
Yeah, I mean, you do find that you can be very creative, and all right, we'll divide up the rights. You'll get the rights in column A, we'll get the rights in column B, and we'll share the proceeds with one another, or we'll agree to collaboratively exploit this particular right together and share the money. And there's a million ways to skin that cat, right? Or you just make a clean break. Okay, we'll take these rights and you take those rights, and we'll never talk to each other again. and we'll just do what we want. And we keep all the money. There's a million ways to, like I said, to skin that cat. But that's where a good mediator with some good business acumen can be very helpful in coming up with maybe a creative solution um, that satisfies both sides and gets the dispute resolved.
I think also coming from within the studio perspective, there's an interesting timing dynamic, right? Because when a big piece of IP is potentially involved in a case, that it may be the claim comes at a juncture where there's going to be some big exploitation that's about to happen. Maybe something's going to be released, or maybe even the studio is trying to do something else with it in a different media of exploitation. If it's an old series and they want to create a film or something like that. I mean, I think it goes back to understanding the business. I imagine when you're advising the studio and really understanding what the stakeholders are trying to do.
Yes, that's true. And again, it also goes to the value and importance of the IP to the business. Is it a core IP that they built a lot of their business around? Right. It's not only is it IP they use in the movie, that they've got merchandise. It's an ingrained part of their theme park that they also operate. I mean, right. So you could see how the IP tentacles can permeate throughout the company and make those disputes really, really high stakes and really more challenging to resolve.
And for the in-house lawyer, really implicate a lot of internal stakeholders and conversations.
Yes, yes,
It has to help them navigate.
exactly.
Yeah. So then let's pivot to I think a topic I'm sure you come across all the time in your cases and your settlements, which is confidentiality, right? Within the entertainment industry, for high profile disputes, how important is confidentiality as part of the settlement structure? Is it something you're dealing with all the time? How do you manage that across large organizations?
Well, first of all, confidentiality is critical, I think, in almost any settlement agreement. In fact, I can't remember a settlement agreement I've done in probably 10 or more years that didn't have a confidentiality provision of some shape or form. Um, you're right. A lot of times, the confidentiality being imposed on the company side is a little bit more difficult to honor and ensure that you don't breach. And so a lot of times, I will put in a one-way confidentiality provision for that reason. And when the other side pushes back, I will just tell them it's not a practical thing that the company can agree to, or if they are going to agree to some form of confidentiality clause, it has to be, limited and tailored to specific classes of people or specific types of conduct so that, they can't claim that, some low level employee said something, disparaging or reveal something confidential about the other side, and that all of a sudden gives them a claim against the studio or the company. The other thing, and I run into this just recently, is that not only do you need to have a confidentiality provision, but I also advise that you have a provision that says that other than enforcing a breach of the settlement agreement cannot be used for any other purpose, including as the basis of a separate claim or as evidence in support of a claim in the future. And I'll tell you how it arose. I had a matter for a client who had been, I don't know if they were sued, but they had been accused of copyright infringement of a particular work, along with a bunch of other defendants or companies, and they settled the case. Um, had the typical whereas clauses and the like about, the lawsuit was filed, dispute, denied, but there was a settlement, and the client ended up getting a claim by the same plaintiff alleging infringement of that very same work, and they kept relying on and pointing to the settlement agreement. It's kind of like evidence as to why my client is going to be guilty of willful infringement if this thing ever gets in front of a jury. And so, and it was infuriating my client, right? They were kind of a periphery party in the first settlement agreement. And I don't even think they paid any of the money because they were totally indemnified. And now the settlement agreement is being used by that same party and thrown in their face as evidence of willfulness. And so I made them agree to specific language in the settlement agreement because of that experience. And look, not only is it going to be confidential, it expressly says this settlement agreement, other than to enforce it, cannot be used as the basis of a claim or as evidence in any claim in the future against my clients. And the other side actually pushed back on that initially, and I said, "You must be kidding! You've heard how upset my client has gotten every time you bring up the settlement agreement in these settlement negotiations, yeah, this is almost going to be a deal breaker for us because we don't want in the next situation for you to be running around with two different settlement agreements trying to say, now this is three strikes you're out. Here we are again, judge and jury. This is the third time they've infringed my rights. You got to throw the book at them. And so they ultimately relented and we got the case settled. But I just mentioned that because it's not just general confidentiality that's necessarily important. It's making sure that the settlement agreement can't be used as a sword in some kind of future dispute other than a breach of the settlement agreement itself.
I mean, it's a fascinating dynamic to think that sort of boomerang came back around. We sort of, encourage settlement as a way to lead to finality, right? And that it's not an acknowledgement of liability, but have it wielded as a sword like that. Yeah, I can imagine that.
Yeah. My client was very annoyed every time the other side brought it up. I can tell you that much.
Yeah, it's well. So apart from confidentiality, when you deal with these high profile disputes, I mean, how important is it to sort of talk about a joint statement or going back to this idea of managing the narrative? Is that something that you come across as a point in your mediations and settlement discussions?
Yeah, a lot of times we'll negotiate a joint press release or joint statement, or what I do more often probably than that is negotiate, what the statement will be if anyone is asked about the matter, right? And the parties will agree, some language like, the matter's been amicably resolved or something like that. And so that each side kind of has a standard pre-approved response if asked. Um, a lot of times, it just depends on the situation. I'm not necessarily always a big fan of issuing a press release that a case is settled unless it's necessary or appropriate for that particular circumstance, because a lot of times all you're doing is republicizing the fact that there was a dispute when you issue that statement oftentimes. And so you need to have a reason other than wanting the world to know that it's resolved to do something like that for it to make sense. In my opinion, now, I think opinions can vary on that, but that's kind of the way I think about it.
Yeah, there is sort of this feeling that everybody needs to sort of get their story out, or that when something comes out, the world is going to pay attention. But to some degree, people move on pretty
People
quickly.
move on pretty fast, and all you do is remind them, right? It's almost like the advice a lot of people give people who want to bring, a lot of attorneys give this advice to people who want to bring defamation claims. It's like, everyone's already forgotten about the alleged defamatory statement that the guy said 2 weeks ago. But I can tell you what, when you file a lawsuit tomorrow, it's going to get a whole other news cycle, and everyone's going to remember it again. And you're just republishing the thing that you were upset that was published in the first place.
You're the one that breathed life back into it, right?
Back into it, right? Everyone's moved on. No one
Well,
remembers it, and now you're going to remind them.
Yakub, it's been a fantastic conversation. We're at the top of the hour. I mean, I guess I'll close with one more question for you because we've talked about, some things that mediators do that are effective that have worked for you in terms of communicating with the client, putting on the business hat. Is there any sort of final takeaway that you would offer to our audience? So one of the things that Jeff sometimes asks is, what does the golden mediator do in your kind of case that you like to see? Is there anything that comes to mind as a parting thought for our audience when it comes to either dealing with studios or talent and just navigating this ecosystem?
Well, I think making sure the mediator comes in prepared, has done the homework, knows who the parties are to the extent possible. Hopefully, has done the pre-mediation conferences with the lawyers to kind of get a sense of who the players are, what they're about, what the dispute's about, what the different interests are, including the private caucuses with each side separately, I think helps. And then just really being a good active listener to all the parties, especially when you're in the room with the talent, because they're going to be much more expressive and be talking about non-legal things more so than you're going to hear in the other room, and just to give that the time and attention that it deserves, and let the client kind of get that all off of their chest so that they can then move into kind of a dispute resolution mode. And the one thing I would say that, and I don't think very many mediators do this, but I did have a mediation recently where the mediator did it, and it reminded me why I hate it so much, is the beginning opening joint session. We have all the parties in the room. I find those to be the most counterproductive. I had a case that I mediated recently where there was real bad blood between my client and the other side, particularly the lawyer on the other side, who was an in-house lawyer who was litigating a case on behalf of their client and was really making real personal attacks on the people on my side. And we selected a mediator, and we said in our mediation statement, we think that there's all this bad blood. We don't really think that a joint session will be productive. Well, he proceeded to conduct a joint session at the beginning of the mediation, and we must have wasted the first hour and a half because my client and the other side just started arguing directly with one another. The judge said, "Well, I guess this was a bad idea." Like, yeah, exactly. We told you not to do this.
It's a controversial subject, and I think Jeff is somebody, for example, you may have had mediations with him where he does them because I think in the right circumstances, when done right, they may potentially be effective. But to your point, it really goes back to listening to the parties, right?
I
Nobody
think
knows.
that's right.
He
I
knows
have
better.
another funny story where this is a mediation I had for a client that was accused of copyright infringement by using a song without authorization in a commercial. And the other side is actually the guy's now a current partner of mine at MSK. He was a young associate at the time. He did this really. Oh, and there was insurance coverage, and so we had our insurance carrier in the room with us. It was at this joint session, and so the other side was the plaintiff, and they went up and they did their presentation, and they were really, hammering the infringement and the fact that, this was a willful infringement by my client, and how terrible it was and how they're entitled to all these damages. Well, they did such a good job that the insurance company said, well, based upon that presentation, I think that this case is not covered because it's an intentional act and it's it's out of coverage because of the intentional act exclusion, and got up and walked out of the mediation. And so I looked at the other side and said, you realize the checkbook just left because of the
Oh my
presentation
God.
you just did.
They call that the law of unintended consequences.
Right. And that was the end of the mediation. We
I thought you
stopped
were going to
talking.
say,
Yeah.
I thought you were going
Yeah.
to
It
say
took,
you did a good
yeah.
job. They made the parties think about things they hadn't thought about before, which can be one of the effective things about hearing directly from the other side. Not in
Yeah.
this. Well, your clients and your colleagues are lucky to have you, Yakub. We are very lucky to have had you here today as well. Really, thank you so much for being generous with your time and your insights and for supporting Bulwark for Food. To all of our wonderful audience members out there, we would ask you to please remember to let us know about the donations that you've made today on Yakub's behalf so we can keep track of them for our running total. And thank you for supporting our program. And Yakub, thanks again for being here today. It was a fantastic conversation, and we wish you the best of success. And thanks for being here.
Thank you, David. Thanks for having me. I really enjoyed it.
Thank you. Thank you. It's been a pleasure. Take care, everyone. With that, we are concluded.
Well, that did fly by pretty fast.
Yeah.
I think it was pretty good.
I'm going to stop the recording. Stop.